Okay, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores?
Present.
Senator Orenshaw?
Here.
Senator Lang? Senator Wynn? Here. Senator Hansen? Senator Krasner? Senator Ellison? And Chair Scheibel.
I am here. Thank you so much. Welcome everybody to Senate Judiciary Committee. We have a couple of bills on for work session today before we go to our bill presentation. So I will start by opening up the work session on AB 25. Mr. McDonald.
Thank you, Chair. Jared McDonald, Research Division. Assembly Bill 25 revises provisions related to offenders, and this was brought by the Department of Corrections and heard on May 2nd. It requires Nevada's Department of Corrections to provide women who are incarcerated to access to annual pelvic examinations and mammography based on certain factors such as age, family medical history, healthcare provider recommendations, or other health-related risks. And there are no amendments proposed for this bill. Thank you, Chair.
Thank you. Any questions on AB 25? All right, not seeing any questions, I would accept a motion to do pass. All right, we have a motion from Senator Wynn, a second from Senator Orenshaw. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. All right, by unanimous vote, the motion carries to do pass AB 25. I will give the floor statement to a volunteer named Senator Wynn. And that takes us to AB 137. Mr. McDonald.
Assembly Bill 137 was sponsored by Assemblymember Torres Fawcett and others and heard on May 9th. This bill revises requirements for advertising the sale of an occupant's personal property to satisfy a lien held by the owner of a storage facility. And more specifically, an owner must either advertise the sale for 2 weeks beforehand in a newspaper of general circulation in the county where the sale is to be held, or advertise the sale for 10 days beforehand on a website that customarily advertises or conducts sales of property. We do have one amendment proposed for this bill. As you'll see in the attached conceptual amendment, Mr. Goldwater with Pinion Public Affairs proposes to retain the requirement to advertise in a newspaper of general circulation, reduce the frequency to post an advertisement from 2 times to 1, remove the requirement to publish a description of the property, and allow posting on a publicly accessible website if there is no newspaper of general circulation. Thank you, Chair.
Thank you, and I understand this removes the opposition from the journeymen. I'm not sure about the other individuals who came in to testify on this bill. Are there any other questions? Not seeing any, I would accept a motion to amend and do pass. All right, we have a motion from Senator Wynn, a second from Senator Lang. All in favor say aye. Aye. Any opposed, nay. All right, the nays are Senators Krasner, Ellison, and that's it. And so with that, the motion carries to amend and do pass. I will assign the floor statement to Senator Hansen. Oh, and that takes us to AB 194. Mr. McDonald.
Assembly Bill 194 was sponsored by Assemblymember Howdegi and heard on April 28th. This bill prohibits the intentional release, organization, or intentional causation of the release of a balloon inflated with a gas that is lighter than air. It sets a civil penalty up to $250 for a single violation and authorizes the AG, district attorney, or city attorney to bring civil action to recover penalties and enjoin violations. There are no amendments proposed for this bill. Thank you, Chair.
Thank you. Are there any questions on AB 194? I don't see any questions, so I'd accept a motion to do pass. All right, there is a motion from Senator Wynn. There is a second from Senator Orenshaw. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. I'll be voting no. I think that balloon makers themselves have been working very hard to try to make balloons out of materials that won't harm electrical lines. And just the whole bill overall just seems a little bit excessive. I'm concerned that people who very innocently release balloons could be find themselves in violation of law, so I will be a no.
All right. And Senator Ellison? All right. Not seeing any further discussion. All in favor say aye. Any opposed, nay? All right, the nays are Senators Krasner, Ellison, and Hansen. With that, the motion carries to do pass AB 194. I will give the floor statement to a volunteer named Senator Orenshaw. And that takes us to AB 291. Not 291, 209.
Assembly Bill 201 was sponsored by Assemblymember Ohrenlichter and heard on May 13th. This bill provides immunity from criminal liability to a prostitute who seeks emergency or medical assistance, and the evidence of the alleged prostitution or solicitation of prostitution was obtained as a result of the assistance. And this applies to any offense committed on or after October 1, 2025. We do have one amendment proposed by Assemblymember Ohrenlichter, and I believe this was discussed in the hearing, and it just adds the word medical in subsection 1 of section 3. Thank you, Chair.
Thank you. Any questions on AB 209? All right, not seeing any questions, I would accept a motion to amend and do pass. We have a motion from Senator Wynn. We have a second from Senator Orenshaw. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay? All right, the nays are Senators Krasner, Ellison, and Hansen. The motion to amend and do pass does carry, and I will assign the floor statement to a volunteer named Senator Lang. And that takes us to AB 239.
Assembly Bill 239 revises provisions related to business entities. This was sponsored by Assemblymember Dahlia. And this, among other things, authorizes the articles of incorporation of a corporation to require certain internal actions to be tried before a judge and not a jury. Excuse me. Authorizes boards of directors to act on agreements, instruments, certificates, or other documents in final or preliminary form as deemed appropriate, and revises steps for the board approval of merger, conversion, or exchange plans, and removes provisions allowing the board to cancel a meeting to consider such plans. And there are no amendments proposed for this bill. Thank you, Chair.
Thank you. All right, we have the sponsor of the bill here, so someone come up with a question. Okay, I tried. But I don't see any questions on this one. I would accept a motion to do pass Assembly Bill 239. All right, we have a motion from Senator Wynn. We have a second from Senator Hansen. Any discussion on the motion? All in favor say aye. Aye. Any opposed, nay. All right, the motion carries unanimously on Assembly Bill 239, and I will sign the floor statement to a volunteer named Senator Lang, again. And that takes us to AB 245.
Assembly Bill 245 revises provisions related to firearms. This was sponsored by Assemblymember Hadegui and heard on March 27th. This bill prohibits a person who is less than 21 years of age from handling, possessing, or controlling any semi-automatic shotgun or centerfire rifle, except for those engaged in certain shooting activities, or who are law enforcement officers, or members, honorably discharged members of the United States Army, or reserves, or a member of the National Guard. And we have no amendments on this bill. Thank you, Chair.
Thank you. I did just want to make one note that we heard this bill back on March 27th in our joint hearing, as it is an Assembly bill. There was an amendment made on the Assembly side, which has already been incorporated into the first reprint that you have in your packet today on Assembly Bill 245. We've not had a subsequent hearing since that amendment was made, but since it's already been adopted, the motion will still be to do pass, not amend, do pass. But I wanted to make sure everybody was aware of those small changes, which Mr. McDonald did just go over in the summary that have been made since our hearing on the bill. And with that, are there any questions? Okay, I don't see any questions, so I'd accept a motion to do pass. All right, we have a motion from Senator Wynn. We have a second from Senator Flores. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. No, first of all, I want to compliment you on the way you ran that committee hearing. It was really very fairly done, and everybody got more than equal opportunity to express their concerns. I expressed them extensively. Thank you very much in that hearing. Still got the same problems. I mean, look, you got people that are 20 years of age, and you're not going to be able to own a semi-automatic shotgun or even handle or have in their possession. So that's just one example of really where this bill just goes way, way, way too far. And we are dealing with the Second Amendment issue. So I will be a strong no on this one. Thank you, Madam Chair.
Thank you. Other questions or comments on the bill? Senator Ellison.
That does use automatic shotguns is because of the recoil. And most women like the automatics because they don't have the recoil. But one of the things that was said in that committee was that you can borrow a gun, but they passed that law several years back that said you cannot transfer a weapon to one person or next. You'd have to turn that into a shop, the gun store, and then the gun store would have to resell it to them, and it'd have to reverse that all over again. So I'm a strong no based on, it should be based on the person and their ability to shoot and handle the weapon. Thank you.
Thank you. Any further discussion on the motion? All right, not seeing any, all in favor say aye. Aye. Any opposed, nay. The nays are Senators Krasner, Hansen, and Ellison. With that, the motion to do pass carries, and I will assign the floor statement to a volunteer named Senator Wynn. And that takes us to the last bill on our agenda for this work session, AB 321.
Assembly Bill 321 revises provisions related to offenders. This was sponsored by Assembly Members Jackson, De Silva, Gonzalez, and O'Neill and others, and heard on May 6th. This bill requires the state forester, fire warden, to establish a competitive hiring program for former offenders who worked in conservation camp firefighting programs. The bill also authorizes Nevada's Department of Corrections in partnership with the Division of Forestry to establish a transitional housing program. There are no amendments proposed for this bill. Thank you, Chair.
Thank you. Again, we have the sponsor here, so any questions on AB 321? All right, I don't see any questions. I would accept a motion to do pass AB 321.
So moved.
Second.
All right, we have a motion from Senator Flores. I'll take the second from Senator Orenshaw. And any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. No, I just wanted to compliment Assemblyman Jackson for presenting the bill so well and for working so diligently with Department of Corrections. I think it's a great program, and I hope it'll help a lot of people make that transition when they get back out after they paid their debt to society and make a nice, smooth transaction back into the rest of society. So I thought it was very well done. Just thought, since he's here, I just thought I'd give him a little compliment. Thank you.
Thank you, and I agree. Anybody else with discussion on the motion? All right, all in favor say aye. Aye. Anybody opposed, nay. All right, by unanimous vote, AB 321, the motion to do pass carries. And I will assign the floor statement to Senator Flores. Okay, Senator Flores. And that brings us to the conclusion of our work session. We will now move into our only bill hearing for the day on AB 192. I will now open the hearing.
Thank you, Chair Scheibel and members of the Committee on Judiciary. I'm Shay Backus, Assemblywoman from District 37 in the northwest part of Las Vegas. It's my pleasure to present Assembly Bill 192 along with Michael Buckley of Fenimore Law. He's down in Las Vegas. He also is our chair of the property law section. We also have online today Jane Sternecki, who is the Legislative Counsel for the Uniform Law Commission. So I'm also here in my capacity as a commissioner for the Uniform Law Commission. I have the privilege of serving as one of our numerous Nevada commissioners. I see Senator Orenshaw's here as well. He also serves as a commissioner alongside of two of our other colleagues. The ULC was established in 1892 to provide states with nonpartisan, well-conceived, and well-drafted legislation. ULC's deliberate and uniquely open drafting process draws on the expertise of commissioners, but also utilizes input from legal experts and advisors and observers representing the views of other legal organizations and interests. That will be the subject to the proposed law. ULC stays up to date by addressing important and timely legal issues. AB 192 includes the Uniform Easement Relocation Act and the Uniform Mortgage Modification Act. The Uniform Easement Relocation Act was approved by the ULC in 2000 to modernize a common law rule that gave easement holders absolute powers to restrict development of land burdened by an easement. And you'll hear more details from Mr. Buckley as to the lack of clear law here in Nevada and the purpose of the need for this. The Uniform Mortgage Modification Act, approved by the ULC in 2024, clarifies and simplifies the law governing modifications of residential and commercial mortgages. At this time, I will turn it down to Las Vegas to Mr. Buckley for some remarks.
Good afternoon, Senators, and thank you, Assembly Member Bacchus. Michael Buckley, B-U-C-K-L-E-Y. I'll give you a brief purpose of the Uniform Easement Relocation Act. Basically, what it does is allows a property that is to be developed, allows the owner of that property to relocate an easement on the property if the relocation fits certain requirements under the Act. And I'll go through those in a minute. Basically, and the example that I've given is there's a Nevada case, St. James property, where the owner of or the developer of a 1,600 acre project wanted to put some curves in a road on the property that was under development, and the beneficiaries of the easement, which were two small lots, wouldn't agree to it. St. James went to the court. The court adopted a liberal rule of law, the restatement, allowing relocation, but it didn't allow relocation if the easement was described. And what this law does is that it sets up a procedure for certain types of easements that can be relocated if through a court proceeding. And with that, I think I'll go through the bill and certainly have open to any questions. And I'll do the Easement Relocation Act first. The Easement Relocation Act is sections 2 through 32, and the Uniform Mortgage Modifications Act is sections 34 to 50. Sections 4 through 21 of the bill contain definitions. And I'd like to point out the definition in section 12.3, public entity, which includes the United States, the state, a general improvement district, a municipal corporation, special assessment district. And basically, this is a change to the uniform law. This act was brought up in 2021 and faced objection from municipalities because it allowed relocation of municipal easements. What we've done through the State Bar and working with the Uniform Law Commissioner, the reporter, added this so that the easements that can be relocated do not include a easement owned by a public entity. The other thing that we did in Nevada, and Utah faced the same problem when they considered this law. They did enact the law similar to what you're looking at now with changes from the uniform law. The other thing that we did in Nevada is we really considered the Easement Relocation Act to address property that's under development. We therefore excluded common interest communities from the bill so that an easement that's created by a declaration in a common interest community is not subject to relocation. So after the definitions, section 22 is the critical section, and that says the easement can be relocated. However, it cannot be used to relocate a public utility easement, a public entity easement, a conservation easement, a negative easement, or an easement associated with a public road. It also excludes an easement created by a declaration in accordance with the provisions of NRS 116. And those are referred to in the Act as the eligibility requirements. Section 23 is critical, and that is those are the standards by which the court will consider relocating the easement. So basically, the court has to find that the relocation of the easement is not going to lessen the benefit of the easement or increase the burden, impair the purpose of the easement, or disrupt and use the use and enjoyment of the easement by the easement holder, impair the value of the collateral or any leasehold interest. So these are section 23 are all the provisions that a court would have to consider in order to relocate the easement. Section 24 outlines the procedure. There has to be a summons, who has to be served by the complaint, and also the contents of the complaint. Section 25 deals with the order that the court would enter if it approves the relocation. And section 26 is another important provision. And basically this says that the person seeking to relocate the easement has to pay all the costs. Section 27 is a basic requirement anyway, but it basically says that the parties have to act in good faith. Section 28 deals with the requirements if there's going to be any construction associated with the relocation. Section 29 has some really legal concepts, basically that the relocation is not a new easement, it's the same easement. Section 30 is also important. Section 30 says, even if the easement has a legal description or the easement document says it can't be relocated, Section 30 says the act would prevail over the contents of the agreement. And Section 31 and Section 32 are customary uniform provisions that the act will be interpreted in accordance with interpretations in other state in a uniform manner. And I didn't mention it, and Jane would tell you as well. I mean, the importance of a uniform act in a state like Nevada, where we don't have as many court decisions, is that we have an act that's been well thought out. It has official comments, and it also has, if another state has enacted it, a Nevada court can look to the decisions in those other states where they consider the same language, and that helps interpret the law and make it clearer. So sections 34 and 50 through 50 are the Uniform Mortgage Modifications Act. And I believe this act was adopted recently in Utah. And basically the purpose of this law is, it deals with the following scenario, and that is where there's a senior mortgage and a junior mortgage. And the common law is basically that if a senior mortgage is modified in a way that adversely affects a junior mortgage, then that modification loses priority to the junior mortgage. And the problem that this act tries to solve is that there's a lot of uncertainty as to what exactly constitutes a material adverse effect on this junior mortgage. So what this law does is that it would create safe harbors, and it basically says it lists 10 different types of modifications, and it says if these modifications are done to the mortgage, these will not affect priority. And one of the important purposes of this, I think, is that it allows a lender and a borrower a greater freedom to negotiate in the case of a loan where there's a default or something, and to avoid foreclosure, to work something out. It gives the parties greater freedom. I pointed out on page 13 of the bill, these are the lists of the types of modifications that are the safe harbors. For example, an extension of the maturity date, or a decrease in the interest rate, or there's other provisions that allow modifications of escrow or reserve requirements. And also another one, an important one, I think, is a modification of existing condition to advance funds. And I think that is very important in the area of a construction loan. If a construction loan agreements have all these conditions to advance funds, and if there is a glitch in development of the project, the lender is faced with arguments, and these have been made somewhere in other states, that say, well, the lender is going to advance the funds even though they didn't have to, and therefore they're going to lose priority. This would say, and it's obviously in the benefit of the project to keep it going, so that a modification of a condition to advance funds would also be a permitted safe harbor. And then 49 and 50 are the same types of customary uniform provisions. And with that, I'm happy to answer any questions, and thank you for your time.
Thank you so much. Are there additional presenters, or are we ready to go into questions? Okay, I'll start with Senator Wynn.
Thank you, and thank you for providing the memo. Were there any amendments since the presentation, that we're looking at here today from the time we were in the assembly, or is everything exactly the same?
Thank you,
And
Senator.
I'm sorry, I should know that, but
Senator Wynn through Senator Scheibel. Shay Backus
please go
for
direct.
the record. No, we have not done any further amendments since you're probably looking at a first reprint.
yes. My next question has to do with, I was reading this memo and I had the opportunity to briefly pull up Senate Bill 106 from the 2021 legislative session. And in addition to, obviously, this bill is brought with some modifications to hopefully address some of the concerns that there were in 2021, as well as it sounds like other states had some concerns, including our neighboring state of Utah. Am I still correct in understanding that as well?
Thank you, Senator Wynn. Shay Backus for the record. You are correct. That was what Mr. Buckley was going into when we were talking about the public easements, and those were pretty much addressed in our actual first draft, not even an amendment. We did that when we brought it before the legislature in AB 192 as introduced.
In that bill, Senate Bill 106 in the 21 legislative session, the 2021 legislative session, not the 21st, or I don't want there to be any confusion, that did not include the Uniform Mortgage Modification Act, which you're trying to include here in this bill. Can you kind of explain why that is being brought in this bill and it wasn't brought before? Is it just, hey, we want to also add this uniform law as well, or do these have to be viewed together as a part of any piece of legislation moving forward in our state?
Thank you, Senator Wynn. Shay Backus for the record. Well, first of all, one reason, and I'm happy to have also Mr. Buckley talk to this from a property lawyer perspective, but the Mortgage Modification Act had not been adopted by the Uniform Law Commission until 2024. So when SB 106 was introduced in 2021, the Uniform Law Commission was probably in the preliminary stages of starting to work on the Mortgage Modification Act. And I see Jane shaking her head. That's correct. She probably was the attorney who staffed that. And for those that don't know, when we're doing acts for the Uniform Law Commission, they usually go over a 2-year plus process, wherein if you have a study committee before, then it could go an extra year. We read it the first summer that we're working on it before the whole body, just to get more input from the commissioners. And then it's worked on with observers another year before we finally put it before the entire body, which are representatives from each and every state, to get it approved. So that's one reason. And the second reason is this is a typical Shay Backus type bill where I'll try to squish in a couple things to make it a little longer bill, but covers a little more. But if Mr. Buckley wants to talk about what I think he kind of explained the importance behind it. But.
I think you did too. Chair, may I ask another follow-up question?
Of course.
I understand that, I guess, the Uniform Easement Relocation Act portion of the bill will provide some clarity. Do we have that same kind of issues when it comes to our existing laws around mortgage modifications, like that section? Do we need to have this part of the bill because we have the same kind of confusion and clarity for practitioners in this area?
Thank you so much, Senator Nguyen, for the question. I will have Mr. Buckley touch on this, but I've actually experienced this personally in my own practice because I do some mechanic lien law. This is a little different. It goes more to a simple refinancing, and I don't want to say simple because I'm sure it's more complicated than that, but they list certain specific areas. Before, there was some common law that we would look to when you're looking at whether a subsequent mortgage could skip any of the other lien holders to go to that first place. This delineates it in statute to make it more clear. And I don't, because I know Senator Hansen is a contractor, and I just looked through the list when he was talking about construction. I think he was talking about loans that may be on the property, whereas with mechanic liens, this would obviously have to be read simultaneously with Chapter 108's priority. But I will jump up to, or guess down, because he's on the screen above me, but he's down in Las Vegas. Mr. Buckley, if you want to opine as to Senator Nguyen's question as well, in the practical sense for the Mortgage Modification Act.
Thank you, Senator Nguyen and senators. This area is even more unclear than any other. In fact, I'm the editor of the Real Property Practice Manual in Nevada that the State Bar published in 2021. And I put together the cases and the section on mortgage modifications and which modifications are of adversely affect and which don't, and it's all over the board. And in the Easement Relocation Act, we actually did have a Supreme Court case, but in this case, there's even less guidance. So this is a really important step forward.
Thank you, Chair. I don't have any further questions.
All right, other questions from members of the committee? I'll go to Senator Ellison next.
Thank you, and thank you for spending time in my office with me. I've got a couple questions, and I still believe in a seller and a buyer negotiating them things out. And to me, whenever somebody comes up to you and says, hey, I want to take this property or buy this property from you or trade a piece of property for this corner, and you say no, and he takes you to court, that is a taking. Is that not right?
Senator Chair and Senator Ellison, Michael Buckley, for the record, I can respond to that. This does not involve a situation between a seller and a buyer. It posits that a person that owns property and they want to develop that property, and there is some kind of an easement, perhaps a driveway, that affects the development of the property. So the court and the owner of that easement is the owner of the property next door. The person who wants to develop the property says, gee, I'd like to relocate my driveway. I'd like to relocate your driveway on my property, and I'll move it over and you'll have the same access. But the person next door knows, hey, this is a big project, I can make a lot of money on this, and they just say no. So one of the great things about this bill, I think, is that, and this is really not answering your question, but because there's the ability to relocate an easement, I think it gives greater impetus to the parties to negotiate a relocation. But again, it does not involve a buyer and a seller. It involves a person who owns property, their own property they already own, and they want to move an access or something on their property to another location without adversely affecting that access.
And I've done this also, and had to move adjustment line between two pieces of commercial property. And so we went to the title company, we sat down and said, okay, we're going to do a lot line adjustment. And it was done in no time at all, and we moved the property line and straightened his up and straightened mine up all at the same time, and it worked out good. But if the guy that owns the easement out front is still impacting the private property, at the house. Is that not correct?
Senator Michael Buck,
Yeah.
go ahead.
Yeah, Senator Ellison, let me kind of chime in on here because I think you may be thinking of it this in the reverse. With lot line adjustments, that's obviously like something where someone's going to acquire either more of your property or you have to acquire more of the adjacent property for purposes of ownership. For the easement, that's usually like a temporary or long-term usage. And I believe we probably had it as an exhibit, the Uniform Easement Relocation Act, a summary, which gives like a really good like picture of you have lot A and lot B, where maybe the easement originally, lot B was a blank lot. And so there was like an access road to lot A, the back road, but then someone wants to develop lot B. And so they simply, lot B, who the owner of lot B wants to move the easement that's going through their parcel to maybe along more the border of the parcel to get to lot A. So they're still giving the person who owns lot A access through lot B, but the owner of lot B is the one that has the easement that they have to deal with. Does that make it, I don't know if that picture kind of
It
sometimes
does
helps
if
this.
it's on the same property line. I agree with you. If it's on the same partial, that makes sense. But if it's not on the same partial and it's out into a driveway, or say you're trying to move it to where you can get access to hit the corner or something, then it's a different story. But if it's between two private properties, in between it, then usually that can be worked out. But I'm still not familiar with this.
Senator Ellison, I just want to chime in. I don't know if sometimes lot line adjustments can easily just be worked out. I did spend the week after our probably last special session in 2023 in court in Reno litigating a property line adjustment. So those still go to court.
Yeah, I just did two of them, and both on commercial properties, and it worked out really good. One was with the city of Elko, and one was with the private property. But can the 34 and 35, the Uniform Management Modification Act, is that a Nevada law?
Senator Ellison, Michael Buckley for the record. The Easement Relocation Act is not presently the law of Nevada. The Supreme Court has adopted the restatement, which is very similar to it, but this would be a modification to that.
Thank you.
I'm going to go to Senator, if you're finished, I'm going to go to Senator Hansen next.
Thanks, Madam Chair. No, we had a very thorough discussion on the bill. I just want to make sure on the record, this has absolutely nothing to do with public easements on public property, RS 2477 easements, prescriptive easements, things like that. Just want to get it in the minutes that this bill in no way impacts any of those. Correct?
Thank you, Senator Hansen. That is correct.
Thank you.
I think Senator Orenshaw had a question. Go ahead.
Thank you, Chair. Thank you, Assemblymember Backus, for presenting the bill, and to our representative for the Commission, and to Chair of our Property Law Section. I guess my question for Mr. Buckley, if this passes, do you think that there'll be less litigation about easements because the law is more clear? Do you think that this will help alleviate some of the lengthy litigation regarding easements on private property? And I wonder if you could talk a little bit about that with your extensive experience in property law.
Senator Orenshaw, thank you. Michael Buckley again for the record. I think, first of all, there's two kind of separate things. One is if there's some question about what the easement actually allows, this won't affect, this is not going to help that. I do think, though, that what this does is that since it allows a proceeding to have a court approve the relocation of an easement, it creates a better incentive for the parties to agree, because now the person who wants to move the easement doesn't want to go to court because it's going to be expensive, and so they're willing probably to pay a little more to the person who has the benefit of the easement in order to relocate it. But then the owner of the easement can't really, do a holdup because there is this ability. So I do think it helps in reducing the litigation. It won't affect, if there's a question, you know, can I have trucks on this driveway or just cars? This won't affect that. But it would be actually, you know, in the process of negotiation, and I don't know why I didn't think of this right away, but, you know, if the developer wants to relocate the easement and there's some question about, you know, what the scope of the easement is, there's a great incentive for the parties to agree then to solve the disagreement or to solve the, you know, what is uncertain about the easement. It's a great opportunity to do that. So I think the answer to the question is yes.
Thank you. I appreciate your input. Thank you, Assemblymember Backus. Thank you, Chair.
All right, any further questions on this bill? Senator Krasner.
Thank you, Chair. Thank you for your presentation. So an easement is a type of real property interest. It grants a specific right to use another's land for a defined purpose, even though the person holding the easement doesn't own the land. However, this is through contract. This is something that is written down, both parties sign, and it is recorded, and it runs with the land. So if somebody's landlocked and they have an easement over another's property for a driveway to get to their house, which is in the back, when it's sold, that goes with the land. The easement runs with the land. Now, you are suggesting in this bill that the two parties no longer have to work with each other on this, but the owner of the land can now go to court over the objection of the lien holder. Is that correct?
Senator Michael Buckley again for the record. I think the example that Assemblymember Backus had of the picture, the owner of the property doesn't. What I think is, the owner of the property is not going to sue somebody to move the easement. That makes no sense at all. You would go to the holder of that driveway easement and say, gee, you know, I'm building my house on this lot and I'd like to move your driveway to the edge of the lot rather than in the middle of the lot. I don't think there'd be any sense for that person to just go to court because it's expensive. They have to pay for everything. So I think the effect of the bill is to really encourage parties to negotiate and resolve things so that because the owner of the undeveloped property has a new tool in their pocket to be able to develop this property, and they can use that tool. And I think it will help the parties negotiate to come to a better, to come to an agreement.
Thank you, Chair. Thank you for that response. And I appreciate your saying, oh, they might not do it. It would be expensive to go to court, but they could do it, correct? Because you did say that in your opening statement.
Senator Michael Buckley for the record. Yes, the person, what this bill does, it allows, if the parties cannot agree, the parties can always agree. There's always the ability of the easement holder and the property that's burdened by the easement to agree to a relocation. There's absolutely, this would not affect that at all. What this does do is that if the owner of the property to be developed wants to move it, they can go to court. I think you would find that the first thing the judge would say is, have you asked this party to if they would move it? I think that would be the first court question the judge would ask. But yes, it does allow a person to sue the owner of that easement and seek a relocation if it meets the eligibility requirement, and if, as it's required in the statute, it meets all the conditions. Basically, is not going to adversely affect the use of that easement.
And then one more question. How many other states are doing this currently?
Senator Michael Buckley. I know that Utah, I'll give you a little background on this because I had the great opportunity to, they have this thing, the American Bar Association presents a Professor's Corner. And they talked about this act. In fact, Jane was one of the presenters on that act. A lot of states already allow relocation of an easement by court decision. In fact, even Nevada allows relocation of an easement, except as the St. James Court held, if there was a legal description attached to it, it couldn't happen. But a lot of states don't need this act because their court decisions already allow the moving of an easement. And basically, it's going to be the same thing. You know, people should be able to move the easement if it's not going to adversely affect the use of that easement. I do know that Utah enacted it. And actually, now that I recall, my note on my memorandum I passed around was that it's been enacted in Washington, Utah, Nebraska, and Arkansas. And it's been introduced in Texas, Oklahoma, and Virginia.
Senator, if I could add, Jane Sternicki for the record, Sternecky. Oklahoma also just passed the act very recently this past session.
So I'm sorry, I wasn't able to count those. How many is that? 6? 5?
That's 5 total.
Thank you.
I think we have a few more questions. I'll go to Vice Chair Flores next.
Thank you. And excuse me, my allergies are still killing me. Always great to see you, Assembly Member. I'm thinking of a hypothetical, say we have Lot A, B, and C. They're all adjacent to each other. And say Lot C holds an easement, both in Lot A and B. Do you see scenarios where independently moving an easement in Lot B doesn't necessarily create a problem for the easement holder, Lot C, but once you move it, it could potentially create a problem because you also have an easement in Lot A where that could be in conflict with each other. How would that play out? I'm just trying to think of a hypothetical where you have two separate easements and interrupting one on its own is not an issue, but it's because of how those two easements intertwine between two separate lots. How would that play out in court? And I'm just trying to think of different hypotheticals of if that could create any scenarios.
Thank you, Senator Flores, for the kind comments of having me here, but also for the question. And I'm going to let Mr. Buckley talk on this, but when I look at it from that perspective, it would seem with B, so if I'm imagining a straight line, like Lot C is the landlocked property, and you have like an access easement probably through Lot A and Lot B. And so if Lot B, the middle property, decided to move their easement, which would greatly affect probably Lot C, I mean, one, I think Lot B would be kind of a little selfish. They weren't working with A and C because Lot B gets the benefit of Lot A potentially if an easement's going through that lot. But I think you could still, I mean, the hard thing is now it's not Lot A, the owner of Lot A that would be moving their lot. It would be basically Lot B that would have to work with C. And I think that would have to, it still would work in essence because you would have a situation where B, I mean, I think C could make a lot of good arguments if it created like something, but it seems to me that it would have to still work because B has to benefit from A, but I'll go ahead and have Mr. Buckley like opine on that if there was the multiple property situation, or even Mr. Sternicki.
Thank you, Senator. Assembly Member Michael Buckley for the record. Two points, Senator, I think. Number one is that in section 24, 2A4, one of the persons that has to be a party to the litigation would be anybody who has the benefit of that easement. So all the A and the B would have to be affected. And the other thing too is that basically the court's going to have to find that it's not going to impair the use of that easement. So that doesn't not limited to moving it on Lot B, but moving it on Lot A, even if they weren't a party. I mean, the court's going to have to find that nobody's going to be suffer because of the relocation. So as you know, I think as Assemblymember Backus pointed out, these things are well thought out. They spend years in putting them together, and I think if you go through it, as I have many times, it's really it's all there. It can't make the easement more burdensome than it is.
Understood, and I appreciate that. And again, I was just mostly trying to walk myself through the exercise of when we have different easements in different properties, but it's just one property that's bringing the suit, how that relationship and interaction would kind of play out. And I appreciate the expertise. And so it sounds like in that scenario, even today with the rules we have now, the court would very likely, or I guess presently, how would it play out today? If you have that scenario where you have you have 3 lots, one lot is trying to make a change. How would that play out in court today? Today would they force all 3 lot owners into the room?
Senator Flores, Michael Buckley again for the record. Absolutely. I mean, the beneficiaries of the easement and the property that's burdened by the easement, they have an interest in real estate, and a court cannot affect that interest unless those people are parties to the lawsuit.
Fair enough. Thank you. And again, I appreciate it. I was just trying to walk myself through that exercise and get there with you. Thank you.
Sure. We're going to go back to Senator Ellison.
And thank you. If you had an A and B up there, but yet you had a piece of property in back that had no access or limited access, then that property is actually almost worthless if they have no access to it. So if the back's closed off and there's easement that goes between the two to go up to that house way up on the top, then that to me would be a reason to go in, and the judge would say, yes, I can understand, because now they have no access to their property. Is that not correct?
Senator Michael Buckley for the record. I think I'm not sure of the question, because if there is an easement for that house up on the hill that's might be landlocked, then they would have to be a party. If there is no easement, then it wouldn't be. There's nothing. I mean, they need to get an easement. It has to be. I mean, what this bill does is it talks about relocating an existing easement. So if the property were landlocked, if the property were landlocked under Nevada law, there's a great likelihood that they would be able to get an easement by necessity, depending upon how the parcels were created. But that is a common law doctrine and wouldn't be addressed by this bill.
Okay. Well, I just see an impact and I've seen several of these in the last near future, where they'd close off, they'd do a subdivision, but the subdivision didn't take the property up above them. So that created a problem, and that created a lawsuit, because now you got a piece of property that might be very valuable that you have no access. So I see where that would fall into this if that was the case. But then the buyer should have knew that. He needed access first before he purchased the property. I hope
Senator
that
Michael Buckley for the record. It certainly makes sense. And I think, again, what you're talking about is an easement by necessity. The courts are allowed to imply an easement under certain circumstances. And where there was, say for example, there was a road there and then a new subdivision came in and cut off that road, there's a good chance that that easement still is there because it was being used in the past, or it might even be a prescriptive easement because of it that it's been used for so long.
other questions from members of the committee? Okay, I have a couple of questions of my own, and I do appreciate you coming to my office to talk to me about these beforehand, but they came up during the hearing. So I think you kind of answered for me what the current law is with regard to like if there are like 3 properties that share easements or have easements, but can you clarify what the process is right now if I'm a landowner and someone else's driveway goes through the side of my property and I want to move that driveway for some reason and the person who utilizes the driveway says no, could I take them to court to force them to allow me to move the driveway, or would the only remedy be for me to move the driveway and wait for them to sue me?
Senator Michael Buckley for the record. I'll just go back to the St. James case, and under the existing law, this is what was adopted by the Nevada Supreme Court. They adopted the restatement 4.8 of property, and it says, it basically says, it says, except where the location and dimensions are determined by the instrument or circumstances surrounding the creation of a servitude, they are determined as follows. The owner of the servient estate has the right within a reasonable time to specify a location. So I don't think that would, and I'm looking, I need to look at subsection 3. Unless expressly denied by the terms of an easement as defined in 1.2, the owner of a servient estate is entitled to make reasonable changes in the location or dimensions of an easement at the servient owner's expense to permit normal use or development of the servient estate, but only if the changes do not significantly lessen the utility of the easement, increase the burdens on the owner, or frustrate the purpose. So what happened in the St. James case, the court took a very liberal position on being able to relocate the easement, but it did say that in this particular case, where the easement was legally described, that they couldn't do it. So in your example, if the easement said, property owner A, yes, you can use my property to access your property, and that was all it said, then the owner could move it. But if there was, under the St. James reasoning, if there was, you get to use the 30 feet on the north side of my property, then I don't think that under the St. James case you could relocate it, and you would basically have to. Well, you couldn't move it. I think that's the result of St. James. I mean, St. James, they wanted to put a few bends in the road, and the court said no. I mean, that was a 1,600 acre development, and the beneficiaries were a couple of lots, and so there were great pressure on the courts to find some help to the developer. The court said no. So under your example, if the person said no, you're stuck.
Senator Schreibel, if I may add on, I think the question you were asking was like kind of who can commence the litigation, and I think it could be either way. So in the St. James, and I'm actually reading Mr. Buckley's memo where he nicely summarizes St. James, so I'm kind of cheating a little based on his work product. In that situation, the developer wanted to do this relocation of an easement that just had curves in it, and so they moved forward and were relying on the restatement, and as most of the lawyers that probably sit on this committee is, restatement of all law is secondary authority, and not necessarily binding law. And so, but it sounds to me the other way is, I'm sure in Nevada, we're all a little loosey-goosey where we may decide to just move an easement on our own, and then we suffer the, we won't ask for permission, we'll just seek forgiveness. And so we end up getting sued. So I think in both situations, it could happen. The nice thing, and I want to take a step back with the Uniform Easement Relocation Act, is right now we're just operating under a Supreme Court opinion that basically adopted the restatement and then separated itself from what the restatement said, in that basically it ruled the developer's easement did not satisfy the restatement conditions for relocation, but the court cited the benefit of the restatement is to increase the value of property burdened by an easement without diminishing the value of the property benefiting from the easement. So right now we're dealing with case law. I think that's not so it's clear, but could be interpreted very differently by our courts. And I think the good thing with something like the Uniform Easement Relocation Act is it's going to give property owners some guidance. So maybe we could avoid litigation if there is a pathway to kind of give us some clear direction under statutory law.
Okay, thank you. My second question is about the owner of the easement and under the uniform law, whether they have any ability to, I guess, request the movement of an easement if the servient property owner makes changes to their property and doesn't move the easement in a way that would be reasonable or predictable. So like going back to an earlier example where you were saying if someone has a driveway going through the center of the lot and then the lot owner decides to build their house in the center, I could see, I don't know exactly how, but I could see a situation where the owner of the easement says, look, I just want my driveway on the side of your house. I no longer want my easement through the center of the lot because I don't want to have to drive past, 3 feet past your house. I just want it on the side. Can you please, if you're going to build your house in the middle of your lot that's been empty for the last 20 years, can you at least move my driveway over so that I have a straight shot to my house? Would they have the ability to exercise the same process as the owner of the subservient estate?
Thank you, Senator Scheibel, for the question. Shay Backus for the record. When I'm looking, and I stand corrected from probably Ms. Sternecki or Mr. Buckley, but when I'm looking at sections 22 and 23 of the bill, actually, it's 23 and maybe 24, it's talking about the servient estate owner and not the other owner in your situation.
Senator, I would be happy to answer this question. Jane Sternecki for the record. No, it does not work the other way. So this act only allows the owner of the servient estate to relocate the easement. And that's because it's trying to address a couple of concerns. First of all, the concern about extortion, where the dominant estate holder has this extreme amount of power over the subservient estate owner, where they're able to say, you can't relocate this easement, you can't develop your property. The second thing we're trying to prevent is land waste due to gridlock. So in a scenario where the two parties cannot agree, sometimes this property just lays in waste because there isn't a clear mechanism to file suit to allow the relocation. Neither of those are really present when we have a dominant estate holder who would like to just move the easement on the burdened property. The power imbalance is really that the burdened property is at a disadvantage relative to the dominant estate holder.
Okay, thank you. And my last question is about the Uniform Mortgage Modification Act. And I want to make sure I'm understanding correctly. This has only been signed into law in Utah so far. And how long have they been utilizing it? Like, when did that happen?
Senator, that's correct. This has only been signed into law in Utah, but that's because it was just promulgated at the end of last summer in 2024. So this is still a brand new Uniform Act. As far as I know, it hasn't taken effect yet, but I will note that we had significant buy-in from throughout the financial and mortgage lending industries. This is all based in common law. The Mortgage Modification Act is the safe harbor modifications that have been identified by that act are based in common law. We're just adding certainty to both lenders and borrowers to make sure that they're able to make those mutually beneficial modifications when that's something that's going to be in their best interest.
All right, thank you. Unless there are any further questions, I think that concludes our questions for today, and we will move now into testimony. We will start with testimony here in person or in Las Vegas in person in support of AB 192. Please come on forward to testify in support. I don't see anybody coming forward, so we will go to the phones, please, for support testimony on AB 192.
Thank you, Chair. There are no callers wishing to provide support testimony.
All right, we will go to opposition testimony on AB 192. Anybody wishing to testify in opposition is welcomed up to the front here in Carson City or Las Vegas. It looks like we do still have Mr. Buckley there, but no one else coming up to the front to give opposition testimony. We will go to the phones for opposition testimony.
Chair, there are no callers wishing to provide opposition testimony.
All right, then we'll go to neutral testimony. Anybody wishing to testify in neutral is invited forward now. Again, I don't see anybody coming forward in our in-person location, so we'll go to the phones for neutral testimony on AB 192.
Chair, the public line is open and working. There are no callers.
All right, then that concludes our testimony. Unless the presenters have any closing remarks based on all of that testimony, I will go ahead and close the hearing on AB 192. Thank you so much for your presentation and for being here today. That brings us to the last item on our agenda, which is public comment. Anybody wishing to give public comment in person is invited forward to do so now. And it looks like we may have somebody in Las Vegas who wants to make public comment. Please go ahead and try to limit your comments to about 2 minutes.
Hi, my name is Brandon Buchholz, Buchholz. As a student, I've been tracking AB 245, but I did not receive any information on the previous sessions. Would you allow me to give my testimony now?
I'm sorry, on AB 245?
Yes, the one on semi-automatic shotguns and centerfire rifles.
Oh, I'm sorry, we don't take testimony during public comment or during work sessions, but if you'd like to submit it to us in writing, we would be happy to include it in our official record.
Okay, thank you.
Thank you. Anybody else wishing to give public comment in person? Not seeing anybody, we'll go to the phones, please, for public comment.
Chair, the public line is open and working. There are no callers.
All right, then that brings us to the conclusion of our meeting. If you didn't have time to give testimony or have public comments that you want to submit, you're always welcome to submit those to our secretary via the email address that should be placed on the agenda, which is also in the room with you. It is senjud@sen.state.nv.us. And with that, we do have a meeting tomorrow. It will be at the call of the chair. My intent is to try to get us in here earlier than our usual 1 p.m. time, dependent on the other morning committee's schedules. So we'll, as always, try to send out information to our distribution list, and you can always swing by my office and find out how the day is looking. So until we see you tomorrow, we are adjourned.